and it would be impossible for them to monitor all of their property at any given moment.
Right, but I think the distinction there, Gavin, is, and again, people should be reminded, municipal governments are not constitutional governments; they're creatures of statutes.
Hello and welcome to the next episode of Beneath the Law. I'm Gavin Tighe here with my partner and friend, Thiele. Stephen, how are you today?
I'm doing great, Gavin. The New York Yankees are no longer in the playoffs, my friend.
Yeah, we're recording this right after the Blue Jays' historic win, so we're all excited here in sunny Toronto. The Leafs won, the Blue Jays won. Oh my goodness! Start playing the parades. Let's go.
The Leafs won. Oh yes, they played those dastardly Montreal Canadiens last night, huh?
Absolutely, great night in sports in Toronto and in New York. Too bad for you, New York. They've won enough. They've won enough. It's our turn. We need a little winning in this side of the border.
The Yankees are on a 16-season drought. They haven't won in a long time.
Well, they always seem
they're
to be
not
in
happy.
The mix. They always seem to be in the mix. I don't know. Anyways, we're speaking of in the mix. We've got a case that came out of the mix of the Supreme Court of Canada.
And it's a mixed decision.
It was a very mixed decision. A case called Koki versus the City of Toronto, which has gotten quite a bit of airplay and attention for a real estate case, which oftentimes don't get a lot of attention. In this case, certainly did. Because it relates to a topic that a lot of people have some knowledge about and interest in, certainly, respect of what's called squatters' rights, or the ability to gain title to property by possession of the property and exclusion of the rightful property owner. In this case, maybe you could tell the listeners about just sort of the facts that went into this case.
Sure, and I live actually very close to this area of the city of Toronto. It's along the Humber River. Etienne Brule Park, which is down by Old Mill Inn, Bloor Street in the Humber River. Property owner basically fenced in some land that was dedicated as parkland for public use. And had it fenced in for many, many years. Conservation Authority had taken over this land in, I think, 1958, then transferred it to the City of Toronto in 1971. The city hadn't realized that the property owner had fenced in along the parkland, and eventually the owner of the property said, "Hey, that's my land," and brought an application to court claiming it. Lower court and the Court of Appeal for Ontario sided with the city, and the Supreme Court of Canada reversed that judgment and gave the land to the owner gave it to the person who had fenced in the land and made them the owner of it.
Right. In a as you pointed out, a split decision, a 5-4 decision of the Supreme Court of Canada. So basically, one judge tipped the scale here in favor of the what I'll call adjacent property owner, the squatter, for lack of a better word, or the successor entitled to the squatter. Because, I mean, as you point out, this land, the history of it was that it was, and I understand it was a fair chunk of property, 3,600 square feet or something of that nature.
Yeah, it's pretty, the property there, if my recollection is correct, because it's also a laneway that goes in behind these houses. Probably had some form of garage area there or something or other. But the property, I think, sits up on a slope. And so it's the property that's higher up above the slope that was probably the property that was fenced in. But I think you're right. Something like 3,600 square feet.
Yeah, and certainly
that's lots.
That's not nothing. And particularly, in my view, it also adds significantly to the value of that property because, of course, property, sure, properties are properties in the sense that, there's a house on them and whatnot, but the development potential for that property and the ability to build a structure there, another house, you could build a much, much bigger house if you have a larger envelope of land. And they would have added, of course, to the envelope, the lot size, and therefore the development potential of that property.
Yeah, I think you're right, Gavin, because that would certainly adjust your setback line and your ability to build as of right.
That's correct. So, and I mean, curiously, the owner of the property was the city of Toronto, who would have to authorize the building in the first place. But I think that the point being that I think you are permitted as of right to build so many square feet of house, depending on the size of the lot. And as you point out, the setback issues. So all in all, a significant windfall, frankly, for the property owner in a large respect. Although, bearing in mind, and we don't know all the facts here because we weren't involved in the case, but these people were not the original owners. As you pointed out, this property had originally been owned by a conservation authority and been given to the city. It was unclear when the fence went up, although I think it went up almost immediately. So the people who own the property now aren't the ones who acquired it without the title. They acquired it thinking that they had this piece of property in their backyard, or this was their backyard, not the city's parkland. So they may have paid for it. We don't know that.
No, I think they bought the property in 2007.
Right.
Or thereabouts. And the prior owner had the fence already there, is my understanding. I think the fence was there in 1971. There was a survey done that seemed to have showed this fence. So, you're coming as buyer, taking a walk and tour of the property when you buy it, and you think, oh, well, by the way, that's pretty good. I've got all this land.
Yeah,
except it wasn't theirs.
Yeah, no, I agree with that too. But I mean, I'm a little wary of that because I mean, I don't know what the actual legal description of this property was. But when you buy property, the way they used to be done many years ago, is that there would often be what's called a meets and bounds description in the title, which would describe how many square, where the fence line was, and it would articulate that in a sense. And oftentimes too, there would be a sketch or a survey, as you point out, that was attached to it or referred to in the legal description. So it's a little strange that the lawyer dealing with the purchase wouldn't have picked up on the fact that, oh, by the way, you don't own that property because it's not part of your legal description. I don't know if it was absorbed into it. I mean, that wasn't clear at all in the decision as I read it.
I agree with you, and we do know that it was in the land title system.
That's
and
hugely important.
Right. And for our listeners, like we're talking Ontario property registration regimes. So we've traditionally had two in Ontario. We have the registry system versus the land title system. The land title system is, I guess, better in terms of knowing exactly who the owner of a property is, and you don't get into the meets and bounds descriptions anymore in land titles, as far as I'm aware.
It still describes somewhere down the road in terms of you describe it as a parcel,
yeah,
but it's there. I mean, it and land titles. I think fundamentally there's some pretty significant differences between what is called the registry system and the land title system. So adverse possession is not available under the Land Titles Act because the notion that there's no ability to acquire title beyond what is in the title in land titles. It's anathematic to it. So there's no land titles adverse possession. And this is curious because, of course, in Ontario, virtually all properties now have been converted into land titles over the course of the last 25 years. I think it's been about in the last, certainly 25 years ago in the early 2000s, almost every property in Ontario was in what's called land titles condition qualified,
right.
So what that meant was that whatever the title was at that moment in time when it was converted was the title. So in this particular case, this is why this is a real historical adventure when you're trying to prove adverse possession in 2025 in Ontario. You've really got to go back to a period of time prior to the conversion into land titles, which means you've got to look at an envelope of time, and in adverse possession, it's a 10-year window. that occurred before the land was converted. So, in other words, sometime in the 1990s, 1980s. And fair to say, it's not that easy to find people who can remember what property was done, what was done to property, what have you, in, 30, 40 years ago, still, knocking about that can give evidence on that.
No, for sure. Now, I think this property, again, recollection, people will have to check the case. I think it was converted into the land title system in 2020, 2021.
Oh, that's late. That's
Right.
late.
So it's a very late kind of conversion. And as you said, it's 10 years, open, notorious, continuous occupation to the exclusion of the owner, the paper title owner, with the intent to exclude the paper title owner. That's the test
Yeah.
for adverse possession.
Adverse. In other words, that the use of the property must be adverse to the interests of the title holder. And, it's one of those concepts that people need to understand, I think, is that permission is not adverse. So if you let somebody do something, they can't get adverse possession against the title. It has to be unwilling or against your interests. So if I let you walk across my lawn, you can't get an easement to walk across my lawn.
And that's where the court seems to split. It's a very interesting decision from the majority to the minority, because the minority accepts a public benefit test that requires actual or constructive knowledge, which is basically a permission based test for adverse possession, which seems to be contrary to what adverse possession really is.
Yeah, no, I think it's a very difficult concept. Adverse possession and the test that goes into it is very strange, because you have to know about it. That's where one of the qualifiers is it's notorious. In other words, it's like it's known, and you can't permit it. So, suffering someone's occupation of your land without saying anything, even with saying something, is actually what is required to gain adverse possession. So, for example, if you told someone to get off of that land, move your stuff or whatever, and they don't do it, that actually helps the people claiming adverse possession in the claim, because what they're saying is, see, it was adverse to their interests. Didn't want me to have my stuff on their property. They told me not to move it. I didn't accede to their request. They certainly weren't permitting me to do it. Therefore, I've got the basis for an adverse possession claim. It's a very odd and archaic, frankly, doctrine.
Well, it's archaic in the sense that it places the onus on the actual title holder to assert their rights, right? The way that the statute is written is, if you don't assert your rights within that 10-year period, you can't assert them afterward.
Yeah, I look at it almost like it's more of a defense than a claim, in a sense. I mean, it gets you the title, but it's a defense to an ejectment. In other words, to say that somebody, if somebody tried to eject me from the property with a trespass claim or something of that nature, I would have a defense that, no, it's now my property. You can't kick me out any longer. So the original codification of the doctrine was actually in the old Limitations Act. So it would have been a limitation defense.
Correct. And we talk about the statute. So in Ontario, we have a modern Limitations Act, which was passed in 2004, and then they kept the old Limitations Act, changed the name to the Real Property Limitations Act, and that's where those provisions in terms of adverse possession entitlement can be found. And what's very interesting, I guess, with respect to the Real Property Limitations Act, Gavin, and this gets into the majority judgment, is in their reading of the relevant provisions, there are exceptions to adverse possession. Certain lands you cannot get adverse possession to, but municipal parkland was not one of the exceptions.
Yeah, that one was a pretty strange thing. So just in terms of the claim for adverse possession, and I've done a couple of these cases over the years, including cases that have gone up to the Court of Appeal for prescriptive easements. They're not easy. They're not easy cases to prove, and they shouldn't be easy. It shouldn't be easy to take away somebody else's property by squatting on it or use of it. So the test is pretty hard to meet in a general adverse possession case. And the usual concept was that, to my mind, was that adverse possession never ran against the Crown. I mean, the Crown was not an entity, that an owner that was susceptible to people adversely possessing property, which makes all sorts of sense, because the Crown, i.e. the government, in one form or another, owns massive amounts of property. I mean, the governments, the provincially, federally, and municipally, have got to be by far and away the largest landowners in Canada. And it would be impossible for them to monitor all of their property at any given moment.
Right, but I think the distinction there, Gavin, is, and again, people should be reminded, municipal governments are not constitutional governments; they're creatures of statutes.
Correct.
Right, so they're corporations; they're not considered the Crown in that respect.
Correct.
So it makes their life a little bit more challenging, but they still face the same problem as the federal or provincial Crown would, with respect to monitoring every stick of land that is owned by the municipality. And here we have parkland. Etienne Brule Park is huge, and it's there's forests,
and one of thousands of parks in the city. Right. That people's backyards vent back onto or adjacent to. I mean, the notion that the city would have to go around literally riding fence of all their parklands and all the time to make sure no one has moved the fences onto the park is an absurd proposition, frankly.
Yeah, and let's get a little bit. I'm going to ask you a question about tactics, because throughout the decision we see comments made that the city conceded the adverse possession.
Yeah, it was right in the first part of the decision,
right, second
of the
paragraph,
majority.
Right.
Yeah, the city conceded that the elements of adverse possession were met, and they hung their hat entirely on, but that doesn't apply to us because we're the city. We're a municipality. That was the entirety of the city's, as I could gather from the majority position. And I frankly think that was a tactical mistake, as it turned out, because I do think it would be extremely hard for the landowner to say that their use of the property was adverse to that of the city if the city's evidence was, we held our interest in holding the property was to own the property. If that was the case, then who cares what they did with it? Who cares if they fenced it off? It wasn't adverse to the city's interest. The city could say it wasn't notorious. They could make all those arguments. I mean, there's been lots of cases where the use of property that you would think is adverse wasn't adverse. I mean, there was a case out in Oshawa where people were landing planes on some guy's field, and that was not considered to be an adverse use because the owner said, I don't care if they land planes on my field. My interest is in holding the property. So why the city conceded that, I have no idea.
It just, to me, it feeds the majority's argument. Once you concede the adverse possession, for the majority, all they're doing is looking at the statute and, applying their rules of interpretation and saying, look, if the province wanted to exempt municipal parklands from adverse possession, they could have done so.
Right.
And they didn't.
Well, and I expect
so there's a lot of difference.
We might be seeing an amendment to that legislation. But exactly, but that just strikes me as being. It was a remarkable decision. The minority didn't take the bait on that. They were of the view that, but we can read into it that there was a public purpose to that land, and therefore that trumps the interest of the private interest of this particular property owner to possess it. So they did not agree that the restrictions in the act exempted parkland from the coverage of that legislation.
This case is really instructive for those of our listeners who are law students within the law schools or even in classes taking law in college or at university. How the majority says that one of the sections of the Real Property Limitations Act provides an exhaustive list, and that
Right.
it's closed off. And the minority says, no, it's not an exhaustive list. We can apply a common law test. And so it's just interesting from how judges frame their reasons in order to justify their conclusions.
Yeah, I mean, for whatever reason, it's difficult to understand from the court's perspective, particularly here. I mean, we haven't read all the evidence, obviously, but I mean, we've had at least a total. So let's do the tally. We have 5 judges who believe that there was adverse possession and that they should get title, and we have a total of I
No,
guess we
it's
have a
6.
total of.
It's 6 because there was a dissenting decision in the Ontario Court of Appeal.
That's right. Which is how they got leave in the first place.
Correct.
So there were six who agreed, and I suppose that there were almost 7 that didn't. Right. So, but the 6 beat the 7 in terms of the Supreme Court of Canada, because 5 of those judges were on the Supreme Court of Canada.
Right. And they're the only ones that matter.
They're the only ones that matter. I mean, you and I have been to the Supreme Court of Canada once, and I recall that as we walked out of there with these bundles of boxes with respect to the file, I was like, well, we might as well throw them in the river because there's nowhere else to go. And this file is finally done. It's at an end. So,
and that was a 4-3 decision.
that was indeed. Indeed. So, that it does raise the possibility that this may be revisited, although I think that it does turn on its particular facts. Although there may be a plethora of claims of people who have property that backs onto parks that the fences have been maybe misplaced over the years, that now come along and say, "Oh, me too. We want adverse possession of our title on the lands that are in the back of our home as well."
Yeah, I would think, Gavin, if I was the provincial government here in Ontario, I would move pretty quickly to amend the legislation to basically diffuse this decision and just protect municipal parkland. We're seeing it in other contexts with respect to encampments. I think people really do need to understand that properties that are dedicated for public use are for everybody, and that not one owner or one group should be able to easily occupy municipal parkland and then make
take
some
it
kind
away.
of claim. Yeah, to take it away from public use, which is what happened here.
Yeah, that's exactly what happened here. Now, in fairness, it hadn't been that particular piece of property hadn't been used by the public because it was fenced off. It was, in any kind of practical or real life application, it was certainly being possessed by the homeowner. But you're right. I mean, these are public spaces. They are owned by municipalities for the benefit of all the citizens of the city and the country or what have you. And for one or 2 individuals to say no, that's mine, should be difficult. Should be extraordinarily difficult. And I was a little surprised here. Well, the city did concede the point, but I would think that there's a huge public policy reason why that should not be the case, why it should not be the case that people are entitled to take away public lands for private purposes.
Yeah, and particularly in this park too, Gavin, that I'm sure that there's probably, it went to the Regional Conservation Authority originally. I wouldn't be surprised that the property in question or that postage stamp or 3,600 square feet might still be subject to TRCA control, Toronto Region Conservation Authority control if somebody wants to build on top of that land.
You raise an interesting question. I mean, we see these encampments all over in city parks all over the city. I mean, let's say the encampment was there for 10 years. Do they own the property then?
Well, if it's registry, you got to be careful.
Exactly.
I mean, they're not building fences per se, but...
Well, the city would have a good defense because they seem to permit it. So they would have a hard time saying it was adverse because they seem to be look the other way, know what's happening, go, well, it's all okay.
I hope Councillor Bradford, who has announced that he's running for mayor, is listening to our podcast.
Yeah, no kidding. No, permission might be a good defense to adverse possession, but not probably a good approach to use of public spaces by private individuals.
Yeah, that's for sure.
Homeless or otherwise. In any event, Stephen, a very interesting case. It shows that the law, I had thought that adverse possession, frankly, as cases go, given the conversion to land titles in the province, had really faded into historical interest only, but apparently not. So it shows you that the law is alive and well, and that these kinds of doctrines come along, and we've got a homeowner now with a lot more property than they had before as a result.
Yeah, and who knows what's going to happen? He's taken public lands legally under the law, but I'm sure environmental groups or other groups that really treasure the public use of land may not be looking too favorably on that landowner.
No, absolutely not. Anyways, it always shows you that if no one is above the law, then everyone is beneath it. And thanks so much for joining us. Please rate us, give us your comments, criticisms, ideas for new shows and new episodes. Always looking for new ideas and new takes on how the law applies in everyday life. So, Stephen, thanks again, and we'll see you next time.